Case 1. Aaron Strotman. 9 infants, 9 fractures, 1 registered nurse with access to every single one of them. That is where this case begins. Aaron Strotman was a registered nurse employed at Henrico Doctors Hospital, a major medical facility located in western Henrico County in the Richmond metropolitan area of Virginia. She was not a new employee. She had been hired by the hospital on September 1, 2019, initially assigned to an adult care floor where she worked without incident. In May of 2022, she was transferred to a unit that demanded the highest level of patient trust and clinical precision in any hospital environment, the Neonatal Intensive Care Unit, commonly known as the NICU. The NICU is where premature infants go. It is where infants born with medical complications requiring around-the-clock monitoring are kept alive by machines, medications, and the hands of trained nurses who work 12-hour shifts in a carefully controlled environment. These patients weigh ounces, not pounds, in some cases. They cannot communicate in any way. They cannot indicate that something is wrong. They cannot tell a visitor, a doctor, or a parent what happened during the night shift. The NICU is, by its very nature, a unit without witnesses among its patients. Between 2022 and 2024, 9 infants cared for in that unit were found to have unexplained bone fractures. Let us be precise about the timeline, because the sequence matters to understanding how investigators built this case. The first cluster of concerns emerged in the late summer of 2023. Between early August and early September of that year, 4 infants in the unit were found to have injuries. Medical staff identified the injuries. Imaging was obtained. The fractures were documented. On September 21, 2023, the hospital's chief executive officer and its vice president of quality took a step that activated the investigation. They contacted Henrico Child Protective Services and formally reported concern for non-accidental trauma occurring within the unit. Non-accidental trauma. That phrase is the clinical and legal standard for injuries that the evidence indicates were not caused by an accident, a fall, a medical procedure, or a known clinical event. It is the determination that sets a child abuse investigation in motion. At that point in September of 2023, no criminal case was filed. No arrest was made, but the hospital and the investigating agencies knew they had a problem inside that unit, and they took a significant operational step in response. They installed video surveillance systems in each individual NICU patient room. They also mandated child abuse recognition and reporting training for all staff who worked in the unit. Those decisions, the cameras and the training, would become central to everything that followed. A second significant injury event occurred on November 21, 2024. An infant identified in court and investigative records only as baby YH was found to have injuries consistent with non-accidental trauma. The medical findings in baby YH's case were specific. The Commonwealth's attorney's records document an impacted distal left femoral metaphyseal fracture, a fracture in the lower portion of the thigh bone near the knee, along with a right proximal tibia fracture and evidence of possible rib fractures. A hospital radiologist who reviewed the imaging, along with a leader of the Virginia Commonwealth University Child Protection Team, both concluded that the injury pattern was concerning for non-accidental trauma. Investigators then turned to the access records. Who was in contact with these infants? The staffing logs and care records place Strotman as one of only 2 individuals with documented access to all 4 of the infants injured in the 2023 cluster. By the time baby YH was injured in November of 2024, the cameras installed after the first cluster were recording. Prosecutors would later state that the footage captured the conduct directly and that Strotman was aware the cameras were recording at the time. Strotman was terminated from her position on January 2, 2025. She was arrested the same day. The charges she initially faced were substantial. The Commonwealth filed 20 counts against her, including malicious wounding and felony child abuse, involving 9 identified infant victims. The case moved through the Henrico County Circuit Court system, and on January 15, 2026, a 2-hour plea hearing was conducted before the judge. At that hearing, Strotman entered a plea of no contest to 9 counts of Class 6 felony child abuse, 1 count for each infant. A no contest plea, under Virginia law and under most jurisdictions in the United States, means that the defendant does not affirmatively admit to committing the acts alleged, but acknowledges that there is sufficient evidence in the record to support a finding of guilt. It is legally equivalent to a guilty plea for sentencing purposes, but it does not require the defendant to say the words. After the Commonwealth's attorney presented its case to the court, the judge reviewed the evidence and found Strotman guilty on all 9 counts. Her defense attorneys maintained throughout the proceedings that there was no evidence of malice in her conduct. They argued that she had been using a technique for relieving infant gas discomfort that she said she had learned from other nurses in the unit. The consulting experts and reviewing professionals rejected that framing. Every medical professional who reviewed the camera footage and the clinical evidence concluded that Strotman had not been improperly trained on an acceptable technique. The evidence, in their assessment, showed conduct that fell far short of accepted nursing standards for any patient, and far short of what was appropriate for medically fragile neonates. On June 5, 2026, the Henrico County Circuit Court judge sentenced Strotman to 5 years of incarceration for each of the 9 counts. That produced a combined sentence of 45 years. All but 3 years of that sentence were suspended, meaning she was ordered to serve 3 years of active incarceration, the maximum term allowed under the negotiated plea agreement. Henrico Commonwealth's attorney Shannon Taylor addressed the sentencing guidelines publicly, noting that the standard guidelines for these offenses had recommended only 6 months for the combined abuse of 9 infants. The agreed sentencing cap of 3 active years represented 6 times the guideline recommendation. As conditions of the plea and sentencing, Strotman was required to permanently surrender her nursing license. She is permanently barred from ever working in healthcare in any capacity, and from working with or having supervisory access to minors or vulnerable adults. The regulatory and legislative aftermath of this case was significant. A state health department review found that the hospital had failed to report the suspected abuse within the required 24-hour mandatory reporting window. The review also found that the hospital had not maintained a reliable system for identifying which specific nursing staff members had provided care to which specific infants, a tracking failure that delayed the investigation. In the Virginia General Assembly session that followed, Commonwealth's attorney Shannon Taylor worked alongside Delegate Dolores McQuinn to pass legislation strengthening Virginia's mandatory reporting requirements in hospital settings. The legislation upgraded the penalty for a first offense failure to report from a finable misdemeanor to a Class 1 misdemeanor carrying a potential sentence of up to 12 months in jail. The hospital reopened its NICU only after completing the installation of room-level video surveillance in every patient room and implementing mandatory abuse recognition training for every individual who interacts with minor or vulnerable patients in the unit. What resolved this case was not a confession, it was infrastructure. Radiological imaging identified the fractures that the naked eye could not see. Access logs and staffing records narrowed the field of people with contact with the injured infants. And the surveillance system, installed in response to the first cluster of injuries, ultimately documented the conduct that formed the core of the prosecution. The Strotman case is a documented example of a unit designed to protect the most vulnerable patients in medicine operating for years without the ability to see what was happening inside it. The investigation forced the construction of a system that could. Case 2. Deborah Sue Damron. A man enters a jail. He has a documented, manageable medical condition. He requires daily medication to stay stable. 4 days later, he is dead. And the nurse's chart says she checked on him when the cameras suggest she did not. That is the core of this case. Deborah Sue Damron was a licensed practical nurse, 56 years old at the time of the events, living in Pikeville, Kentucky. She was not employed directly by a government agency. She was employed by WellPath LLC, a private correctional healthcare contractor that provides medical staffing to jails and detention facilities across the United States under contract with local governments. WellPath held the contract to provide medical services at the Henry County Adult Detention Center in southwestern Virginia. Damron was the on-duty nurse at that facility. The patient at the center of this case was Bradley Stephen Hensley, a 42-year-old man from Bassett, Virginia. He entered the Henry County Adult Detention Center on August 2, 2022, as a pretrial detainee. He had not been convicted of anything. He was being held while his case was pending on charges of petite larceny and possession of burglary tools. He was, in the eyes of the law, a person awaiting trial, entitled to the same standard of medical care as any other person in the custody of the government. Bradley Hensley had a serious, lifelong medical condition: congenital adrenal hyperplasia. This is a hereditary disorder affecting the adrenal glands, which are responsible for producing hormones that regulate the body's response to stress and maintain critical functions, including blood pressure and metabolism. The condition is manageable with consistent daily medication. Without that medication, or without medical monitoring during a period of physical stress, a person with congenital adrenal hyperplasia can experience what is called an adrenal crisis, a potentially fatal emergency in which the body cannot produce the hormones it needs to function. Bradley Hensley was known to have this condition. It was a documented medical need. It was the kind of condition that a correctional healthcare team is required to identify upon intake, document, and manage with a medication plan. He entered the jail on August 2nd. On August 6th, 4 days later, he was found unresponsive. He was transported to Sova Health in Martinsville. He was pronounced dead there. The Henry County Sheriff's Office and the Henry County Commonwealth's attorney opened an investigation. They reviewed the facility's video surveillance footage from the period in question. What that footage indicated, according to investigators, was that the on-duty nurse had not performed the medical checks and monitoring rounds that were required and expected during Hensley's incarceration. Then investigators compared that footage to the written medical chart. The medical chart, according to the criminal indictment, reflected that rounds had been completed and vital sign assessments had been performed, including 2 early morning assessments documented for August 6th, the morning Hensley was found unresponsive. The video record, investigators said, indicated those checks had not actually occurred. The contrast between those 2 records became the foundation of the criminal case. A grand jury reviewed the evidence and on March 20th, 2023, indicted Deborah Sue Damron on 1 count of involuntary manslaughter. She was arrested in Pikeville, Kentucky, on March 22, 2023, and the extradition process to bring her to Virginia was initiated. On September 12, 2023, the Virginia Board of Nursing took separate action. It suspended her nursing license, pending the outcome of the investigation and prosecution. The Office of the Chief Medical Examiner for the Western District of Virginia, located in Roanoke, conducted the autopsy and issued its findings. The documented cause of death was acute fentanyl toxicity, with adrenal crisis due to congenital adrenal hyperplasia listed as a contributing factor. The presence of fentanyl was acknowledged by the Sheriff's Office, and the case proceeded not on the basis that the nurse caused the chemical exposure, but on the theory that the failure to perform required monitoring and the falsification of the chart documenting that monitoring contributed to the outcome. That a man with a known, life-threatening condition was left without adequate medical oversight at a critical time, and that the record was then altered to say otherwise. A parallel civil matter was filed in the United States District Court for the Western District of Virginia. Bradley Hensley's parents brought a federal civil rights and wrongful death lawsuit, naming Damron, Wellpath, and other jail and medical staff as defendants, alleging violations of their son's constitutional rights as a pretrial detainee. On August 6, 2024, exactly 2 years after Hensley entered the jail, the federal court denied the defendant's motion to dismiss, allowing the civil case to proceed. In November of 2024, Wellpath LLC filed for bankruptcy protection, a development that significantly complicated the civil litigation for the plaintiffs. The final disposition of the criminal involuntary manslaughter charge against Damron is not confirmed in the records available at the time of this documentary's preparation. We are stating that directly. No published record reviewed for this production confirms a trial verdict, a guilty plea, or a sentencing. The case was charged and indicted. The license was suspended. The civil matter survived a motion to dismiss. Beyond that, the criminal record is incomplete in the sources available to us, and we are not going to fill that gap with an assumption. The broader significance of this case lies in what it exposed about privatized correctional health care. Detainees with serious chronic conditions are entirely dependent on the facility's contracted medical staff for their medications and their monitoring. The only contemporaneous evidence that care was provided is, in most cases, the chart. When the chart is the document under criminal scrutiny, the accountability system has no independent baseline to check against, unless a camera captured what actually happened. In this case, Investigators said a camera did exactly that. This file turns on a document conflict that required no interpretation of motive and no speculation about intent. A chart said one thing, surveillance indicated another. For a man with a documented, manageable chronic illness, that difference between care that was recorded and care that was actually delivered was, as prosecutors alleged, the difference that determined the outcome. Case 3. Kevin James Coulong. He had been a licensed nurse in Virginia for 25 years. He worked as a certified registered nurse anesthetist at one of the largest hospital systems in Hampton Roads. And between 2017 and 2024, 4 patients filed complaints describing non-consensual contact while they were sedated and unconscious. This is the Coulong file. Kevin James Coulong received his Virginia nursing license in 1999. He had been practicing as a certified registered nurse anesthetist, commonly abbreviated as CRNA, since establishing himself in the Hampton Roads region. A CRNA is an advanced practice registered nurse who administers anesthesia independently or in collaboration with a physician. It is among the most specialized and highest credentialed nursing roles in the entire clinical system. In June of 2008, Coulong joined Atlantic Anesthesia, an affiliate practice of Centara Health, the dominant health system in the Hampton Roads metropolitan area. He practiced in that role until August of 2024, when he resigned. He lived in Chesapeake, Virginia. The nature of a CRNA's professional relationship with patients is unusual in medicine. The CRNA puts patients to sleep. Once sedated, those patients are unconscious. They have no awareness of what occurs in the surgical or procedural suite during the period of their anesthesia. They cannot observe anything. They cannot consent to anything that occurs during that time beyond what they consented to as part of the documented procedure. They are, from the moment anesthesia is administered until the moment they regain consciousness, entirely dependent on the ethics and conduct of the clinical team around them. According to a consent order issued by the Virginia Board of Nursing, Coulong engaged in non-consensual sexual conduct with multiple sedated female patients between 2017 and 2024. The consent order specifically identified incident locations for 2 of the 4 documented cases: Centara Lee Hospital in August of 2018 and Centara Norfolk General Hospital in February of 2024. The other 2 patients, identified in the records as patients A, B, C, and D, reported separate incidents within the broader time frame. The conduct came to formal institutional attention in March of 2024 when Coulong's employer, Atlantic Anesthesia, placed him on a performance improvement plan. That plan required him to complete a course on professional boundaries. He was enrolled in that course in August of 2024. During the course itself, a professional training program designed to address boundary concerns and reinforce appropriate clinical conduct, Coulong made admissions to the course instructor and to other participants. He acknowledged that he had inappropriately touched multiple patients. He was removed from the course. He was referred for a clinical evaluation. Atlantic Anesthesia dismissed him from his position, and he resigned his employment in August of 2024. The Board of Nursing's investigation documented a significant institutional reporting failure. A complaint had been filed regarding Coulong's conduct as far back as 2017. According to the consent order, that early complaint was handled internally by the employer rather than being reported to the Virginia Board of Nursing, as regulatory standards require. Additionally, when Coulong was placed on the Performance Improvement Plan, enrolled in the Boundaries course, dismissed from that course, and referred for evaluation in 2024, the employer did not immediately notify the board, another failure in the mandatory reporting chain that the consent order specifically identified. Because the patients were sedated and unconscious during the events in question, the evidentiary record available to investigators was built primarily from the patient's own reports, from Coulong's admissions during the professional training course, and from a formal clinical evaluation. He underwent a psychosocial and sex offender evaluation conducted by a certified sex offender treatment provider. That evaluation's findings, incorporated into the board's record, described narcissistic and antisocial personality traits and an adjustment disorder. The board also documented a separate integrity concern in the record. Investigators found that Coulong had altered at least one patient's medical record after the fact, adding a retroactive notation about administering medication after he had been questioned about a specific incident. The alteration of a clinical record to create an after-the-fact explanation for conduct that has already been questioned is itself a serious regulatory violation, separate from and in addition to the conduct being explained. The Virginia Board of Nursing's final order in this matter was issued on May 20, 2025. The order required the permanent voluntary surrender of Coulong's nursing license. Permanent surrender means exactly what it says. He is ineligible for reinstatement in Virginia, and because Virginia participates in the Multi-State Nursing Licensure Compact, the surrender applies across all compact jurisdictions. He cannot obtain a nursing license in any participating state. The board's stated basis for the permanent surrender was its conclusion that his continued practice represented an ongoing risk to patient safety. It is important to state clearly what this resolution was and was not. The documented resolution in the public record is regulatory in nature, an action by a licensing board resulting in the loss of the ability to practice. The consent order reflects a signed agreement. Coulong neither confirmed nor denied the board's factual findings in signing it, while the board concluded that he had admitted to the core conduct and that the evidence supported its findings. The records available at the time of this documentary's preparation do not reflect a criminal conviction in this matter. The broader lesson in the Coulong file involves what did not happen between 2017 and 2024. A complaint was filed in 2017. 7 years passed before the case reached the level of a formal license action. The consent order documents that early concerns were addressed internally, that reporting obligations were not met, and that the institutional response was a performance improvement plan rather than an escalation to the regulatory authority. The gap between a first complaint and a final license surrender was 7 years, during which the documented conduct continued. Sedated patients are among the most legally and ethically protected patients in medicine. They cannot testify to what occurred during their procedure because they did not experience it consciously. Accountability in cases of this kind depends on other patients stepping forward to report, on institutions fulfilling their mandatory reporting obligations to licensing boards, and ultimately, in this case, on the perpetrator's own statements during a professional training course. The system that is supposed to protect these patients functions only when every person in that system, employers, trainers, clinicians, and regulators, does what the rules require them to do. Case 4. Juan M. Lopez. A veteran walked into a federal hospital's emergency room in Hampton, Virginia, seeking treatment for a leg injury. She left as the complaining witness in a federal criminal case that would end in a jury conviction. This is the Lopez file. Juan M. Lopez was 52 years old and lived in Virginia Beach. He worked as a nurse in the emergency department of the Hampton Veterans Administration Medical Center, a federal facility serving the active duty and veteran population of the Hampton Roads region. Because the Hampton VA Medical Center is a federal facility, every aspect of this investigation and prosecution operated under federal jurisdiction: federal investigators, federal grand jury, federal court, and federal criminal statutes. On September 20, 2014, a patient sought treatment in the emergency department. She was a military veteran. Her medical record documented post-traumatic stress disorder related to an assault that had occurred during her service, along with the effects of 2 separate traumatic brain injuries sustained during her military career. She came to the emergency room that day for a leg injury. Lopez was the nurse responsible for her care. According to court records and the evidence presented at trial, Lopez administered morphine to the patient contrary to her expressed wishes. He then committed an assault against her during the period of her medical care in the emergency department. 5 days after the incident, on September 25, 2014, federal agents interviewed Lopez as part of the initiated investigation. During that interview, Lopez made a false statement regarding the events of September 20th. That false statement became a second, independently provable criminal charge. This is an investigative and prosecutorial dynamic that recurs in law enforcement with meaningful frequency. The underlying conduct, the assault, may require the jury to evaluate and credit the testimony of the victim over the denial of the accused. That is a legitimate and workable legal exercise, but it involves a credibility determination. The false statement to a federal agent is a different category of evidence entirely. It is an objective fact, what the defendant told the agents, and whether that account was true. When an investigator can demonstrate that a defendant made a statement to federal agents that is demonstrably contradicted by the evidence, the case against the defendant gains an evidentiary component that requires no credibility determination about the victim. The defendant's own words become the evidence. Lopez was indicted by a federal grand jury on July 22, 2015. The case proceeded to trial in federal court in the Eastern District of Virginia. The trial lasted 3 days. The prosecution presented the medical record documenting the administration of morphine, the patient's account of events, documentation of her diagnosed conditions, and the particular vulnerabilities those conditions created, and the evidence establishing that Lopez had made a false statement to investigators. The federal jury returned a guilty verdict on both counts, aggravated sexual assault and making a false statement to a federal agent. Upon the verdict, Lopez was remanded into federal custody. The federal sentencing for these convictions carries substantial penalties, and the conviction on the false statement count added additional exposure beyond the underlying assault charges. The significance of this case extends beyond its individual facts in 2 directions. First, it established clearly that conduct by nursing staff against patients in Federal Veterans Administration facilities is prosecutable under federal criminal law with the full weight of federal investigation and federal prosecution behind it. There is no jurisdictional ambiguity. A VA nurse who commits a crime against a VA patient faces federal charges. Second, the case highlighted the particular duty of care owed to patients whose medical histories create specific vulnerabilities. In this instance, a patient with documented trauma-related diagnoses who was seeking emergency care and was, in the clinical relationship, in a position of complete dependence on the staff responsible for her treatment. The morphine record was in the chart. The patient's account was consistent with that record. The false statement Lopez made to investigators was the element that locked the evidentiary picture into place. In the pattern that we see across this documentary, the attempt to construct a false account of events frequently produces cleaner and more durable evidence than the underlying act it was designed to conceal. Case 5. Adam Hall. 3 patients, 3 separate reports. A suspect identified after the first report who remained employed at the same facility through the second and the third. That is the institutional question at the center of this file. Adam Hall was 29 years old and worked as a patient care technician at Spotsylvania Regional Medical Center, a hospital near Fredericksburg, Virginia, operated within the HCA Virginia Health System. A patient care technician, sometimes called a PCT or a nursing assistant, performs direct patient care functions under the supervision of licensed nurses. They assist with bathing, positioning, vital sign measurement, and other personal care tasks that require close physical contact with patients. Hall had been employed at Spotsylvania Regional since April of 2024. According to the Spotsylvania County Sheriff's Office, Hall was connected to 3 separate incidents involving elderly female patients between January and October of 2025. All 3 patients were over the age of 75. Each was hospitalized and physically incapacitated as a result of a specific medical event. One was recovering from a surgical procedure and was restricted to a stretcher. One was in a post-operative recovery period following hip surgery. The third was being treated following a stroke and had limited mobility as a result. The first incident was reported in January of 2025. After that report, according to the criminal complaint, a supervising nurse at the hospital identified Hall as the suspect in the matter. Hall remained employed at Spotsylvania Regional Medical Center. The second incident occurred while the first matter was under investigation. Hall remained employed. On October 27, 2025, Spotsylvania County Sheriff's deputies were dispatched to the hospital after the third patient reported non-consensual contact and stated that she had repeatedly communicated to the individual that she wanted him to stop. Detectives connected the 3 reports and established them as a pattern of alleged conduct by the same individual against patients who shared a common characteristic. Each was physically incapacitated at the time of the reported incident. Hall was not arrested in October of 2025 when the third incident was reported. The investigation continued. On March 6, 2026, he was taken into custody and charged with 3 counts of aggravated sexual battery involving incapacitated victims under Virginia law. The specific allegation in each count, that the victim was incapacitated at the time is a statutory aggravating factor that elevates the charge and the potential penalty. We are stating clearly that these are charges and allegations. Adam Hall is presumed innocent under the law unless and until a court finds otherwise. His trial was scheduled for July of 2026. If convicted on all 3 counts, he faced a potential combined sentence of up to 60 years of incarceration. The investigation in this case relied primarily on the 3 victims' reports and on the hospital's own internal identification of Hall as the suspect after the first complaint. Because each patient was in a hospital room at the time of the alleged incidents, the investigative record also examined what monitoring, documentation, and access control systems existed in those rooms, and what they could and could not establish about who was present and when. The most significant institutional question raised by this case is not about the alleged perpetrator. It is about the facility. After the first report in January of 2025, a supervising nurse at the hospital had identified Hall as the suspect. He continued working in a patient-facing role. A second incident allegedly occurred. He continued working. A third incident allegedly occurred before any arrest or suspension was made. The entire sequence of events from first report to arrest spanned more than 14 months. The case sharpened legislative and regulatory attention in Virginia and nationally on the question of what hospitals are required to do when an allegation of patient abuse is made against a staff member, whether existing protocols require immediate suspension or reassignment pending investigation, what reporting obligations exist to state health authorities, and how nursing support personnel are screened prior to hire and monitored after hire. These are not rhetorical questions. In the context of this case, they are documented gaps that a prosecution has brought into focus. Case 6. Emily Catherine Poteet. More than 13,000 controlled substance pills disappeared from one Virginia hospital over 2 years. Fentanyl vials were drained and refilled with saline, and the patients who received those vials had no way of knowing their medication had been replaced. This is the Poteet case. Emily Catherine Poteet was 32 years old and worked as a contract nurse at Sova Health Danville, a hospital in the southern Virginia city of Danville, near the North Carolina border. Contract nurses, sometimes called travel nurses or agency nurses, are not direct employees of the hospital where they work. They are employed by staffing agencies and placed at facilities that need temporary coverage. Their access to hospital systems, including controlled substance dispensing systems, is functionally the same as that of a direct hire employee, but the oversight and accountability structures may differ. The Sova Health Danville diversion problem was large. According to the Drug Enforcement Administration and court records, more than 13,000 controlled substance pills vanished from Sova Health Danville over a period beginning in 2017 and extending through the investigation period. That number represents a significant quantity of Schedule II controlled substances, medications classified by the federal government as having a high potential for misuse and accepted medical use, including opioids such as fentanyl, hydromorphone, oxycodone, and morphine. Poteet's specific documented conduct involved a method common to hospital drug diversion cases. She accessed fentanyl and hydromorphone injectables, liquid medications packaged in small glass vials or syringes, removed the controlled substance, replaced it with saline solution, and then returned the container to the supply for administration to patients. Her indictment specifically described the tampering of 3 syringes of injectable hydromorphone between July 1st and October 28th of 2020. To understand why this method is particularly consequential, it is necessary to understand how medications move in a hospital. Controlled substances are stored in automated dispensing cabinets, machines that track every access by employee credential, recording who opened which drawer and removed which medication at what time. When a nurse withdraws a controlled substance injection from one of these cabinets, the cabinet records that withdrawal. The nurse then administers the medication to the patient. If the nurse is diverting that medication, she does so before the administration, draining the vial and substituting saline, and the vial, which now appears intact, goes to the patient. The patient receives nothing useful for their pain. The nurse has the drug. And the automated cabinet's records show a legitimate withdrawal by a credentialed employee, because a legitimate withdrawal did in fact occur. The diversion is invisible to the dispensing record because the record documents access to the container, not the contents of the container. Detection requires the physical testing of vials. Investigators who suspect diversion in a facility must identify vials that have been returned to inventory or not yet administered, test their contents in a laboratory, and compare what the laboratory finds to what the label says should be inside. When saline is found in a vial labeled as fentanyl, the forensic conclusion is clear. The investigation of this matter was conducted by the Food and Drug Administration, the Drug Enforcement Administration's Washington Division, and the Virginia Department of Health Professions. The federal prosecution was handled by Assistant United States Attorney Randy Ramsire. The investigation was not limited to Poteet. A pharmacy technician from Chatham, Virginia, who worked in the SOVA system, was found to have diverted more than 11,000 Schedule II controlled substances from the facility. That individual pleaded guilty to drug distribution and fraud-related charges and was sentenced to 13 months in federal prison in 2020. Poteet's case proceeded to a guilty plea in federal court. She pleaded guilty to 3 counts: tampering with a consumer product affecting interstate commerce, with reckless disregard for the risk of bodily injury to another person, obtaining a controlled substance by fraud, and making false statements. She was sentenced in federal court to 54 months in federal prison, was ordered to pay a $3,000 fine, and was subject to 3 years of supervised release following her imprisonment. Because the diversion was so extensive, and because the system failures that allowed it were so significant, the Department of Justice also pursued civil penalties against the hospital system itself. The SOVA health facilities in Danville and Martinsville were ordered to pay $4,360,000, described by the Department of Justice as the 3rd largest civil penalty ever obtained from a hospital system under the Controlled Substances Act, and the largest such penalty ever obtained within the 4th Circuit of the federal court system. The settlement also imposed 4 years of enhanced compliance and oversight obligations on the health system. The Department of Justice framed the hospital penalty around an accountability principle that applies across the healthcare industry. Facilities that store and dispense controlled substances bear a legal responsibility for safeguarding those substances, and a failure of that responsibility, whether through inadequate dispensing controls, insufficient auditing, or failure to act on warning signs, carries civil liability independent of the liability of the individual who committed the diversion. The Poteet case sits within a broader national pattern of hospital drug diversion that federal enforcement authorities have made a sustained priority. Every hospital that dispenses controlled substances faces the same structural challenge. A dispensing record documents who accessed the container, not what the container contained. Addressing that gap requires physical reconciliation of vials, laboratory testing of suspect inventory, and data analysis of access patterns to identify outliers. The facilities that were penalized in this case did not have adequate systems to catch what was happening inside them until thousands of doses had disappeared. Case 7. Teresa Kiter. A routine inventory count at an urgent care clinic in Colonial Heights, Virginia. An employee counting controlled substances. A vial cap that did not sit flat. 1 suspicious cap. 52 tampered vials, and 14 potentially affected patients later. The investigation was underway. This is the Kiter file. Teresa Kiter was a nurse at a patient-first urgent care location in Colonial Heights, Virginia, in the Tri-Cities region south of Richmond. Patient First is a chain of urgent care clinics operating in Virginia and neighboring states. Unlike a hospital emergency department, an urgent care clinic treats lower acuity conditions, infections, minor injuries, and the kinds of routine medical needs that do not require a hospital visit. Controlled substances are present in the clinic inventory, but in significantly smaller quantities and with fewer patients needing them than a hospital might see. Kiter was not only a nurse at the clinic. According to court documents, she was also a registered patient at the same facility. That dual status, as both a clinical employee with access to controlled substances and a patient at the clinic, would later become part of the investigative picture. According to court documents, the alleged tampering occurred between June of 2024 and February of 2025. The controlled substances involved were meperidine, a prescription opioid pain reliever, and morphine. Investigators allege that Kiter adulterated, mishandled, and diverted these medications for her own personal use. The total number of tampered vials identified in the investigation was at least 52, with more than 30 confirmed as having been manipulated. The discovery began on January 21, 2025. A patient-first employee was conducting a routine controlled substance count, the standard process by which a clinic or pharmacy compares its physical inventory of controlled drugs against the records showing what should be on hand. This is not an extraordinary procedure. It is a required, recurring function at any facility that dispenses controlled substances. During that count, the employee noticed something specific. A 50 milligram meperidine vial had a cap that was not seated correctly. The cap did not sit flat against the vial neck, the way a factory-sealed vial's cap sits. That one cap began the investigation. The clinic reported its concern to the Drug Enforcement Administration. A Virginia Department of Health Professions investigator was assigned. During the investigation, Kiter was interviewed. According to court documents, she described her mental state during the period of the alleged tampering as a manic episode and stated that she tampered with the medications as a way to feel in control of something. Court records also reflect a documented history of mental health diagnoses, including bipolar disorder, which was presented as context for the statements she made during the investigation. The investigator also reviewed Kiter's own patient records at the clinic. Those records, according to investigators, suggested a pattern consistent with drug-seeking behavior. The forensic method described in court documents follows the same pattern documented in the Poteet case. Kiter allegedly took vials into a bathroom, emptied their contents, refilled the vials with saline solution, resealed the caps using adhesive, and returned the vials to the supply box. A vial returned to the clinic's inventory in this condition looks, from the outside, like an unopened, properly sealed unit. It will pass a visual inspection unless someone holds it up and notices, as the counting employee did in January of 2025, that the cap does not sit quite right. The clinic's response upon discovering the issue was to determine how many patients might have been exposed to compromised medications. They identified 14 patients as potentially affected and made contact with each of them to advise them of the situation and to confirm whether any of them had experienced a problem attributable to receiving an adulterated medication. Kiter was terminated from her position on March 3, 2025. She was subsequently charged with 15 felony counts of adulteration of drugs, 15 felony counts of illegally obtaining drugs, and 1 count of possessing a Schedule I controlled substance. We are stating clearly that these are charges and allegations. Kiter is presumed innocent unless and until a court makes a contrary finding. The documentary record reviewed for this production does not reflect a final verdict or sentencing, and we are presenting this as a pending matter. The significance of this case in the context of controlled substance diversion enforcement lies in the detection mechanism. No complex data analysis was required. No laboratory testing of vials caught the problem after thousands of doses had disappeared, as occurred in the Sova case. The discovery happened because a clinic employee counted the inventory carefully and noticed that 1 cap did not sit flat. The routine audit process, which exists precisely to catch discrepancies between records and physical inventory, functioned as designed. The cap was the clue. The count found the cap. Case 8. Colonial Heights Rehabilitation and Nursing Center. 18 employees charged. A 74-year-old resident with cerebral palsy and diabetes admitted to the hospital and then dead 3 weeks later. Text messages between staff members discussing which residents did and did not receive their medications. Charts recording care that the evidence said was never delivered. This is the Colonial Heights Rehabilitation and Nursing Center file. The Colonial Heights Rehabilitation and Nursing Center is a skilled nursing facility located in Colonial Heights, Virginia, owned and operated by Innovative Healthcare Management, LLC. A skilled nursing facility is a long-term care setting that provides medical services, rehabilitative therapy, and custodial care to patients who require more support than can be provided in a home setting but who do not require acute hospital care. The population of a skilled nursing facility is typically elderly, frequently has multiple diagnosed conditions, and often includes individuals who have limited ability to communicate their needs or to advocate for themselves. The federal quality rating for Colonial Heights Rehabilitation and Nursing Center was low. Staffing levels at the facility's parent company's locations were documented as below the national average. These are not background details. They are the documented condition of the facility before the investigation began. a facility already operating below established standards of care before any individual criminal conduct was alleged. The investigation was initiated by a report filed with Virginia Adult Protective Services on October 5, 2024. The report concerned a 74-year-old resident with cerebral palsy and diabetes. That resident was subsequently hospitalized. On October 29, 2024, the resident died. The Colonial Heights Police Department, working in coordination with the Colonial Heights Commonwealth's attorney, began arresting facility employees on December 18, 2024. By December 19, 2024, 16 individuals had been taken into custody, with 18 named in total across the criminal proceedings. The investigation involved the Colonial Heights Police Department, the Colonial Heights Commonwealth's attorney, the Virginia Attorney General's Medicaid Fraud Control Unit, the Office of the Chief Medical Examiner, and the Virginia Department of Health. The breadth of the investigative coalition reflects the nature of what was alleged, not an isolated incident by one employee, but a pattern of conduct across a facility involving multiple staff members over an extended period. Investigators obtained search warrants and extracted text messages from the devices of staff members. The content of those messages, as described in the search warrant applications and court filings, was central to the case. According to the warrants, the messages included staff members discussing which residents received their medications and which did not, with at least one message stating explicitly that residents who could not communicate did not receive their medication. Let that sink in for a moment. The patients least able to report a problem, those who could not speak, could not call for help, could not tell a family member what was happening, were allegedly the patients whose care was most easily skipped. The forensic and clinical evidence presented alongside those text messages addressed the medical records directly. Prosecutors alleged that documentation in the facility's charts showed staff had recorded the use of a Hoyer lift, a mechanical device used to move patients who cannot move themselves, for the deceased resident when the lift had not actually been used. Wound care was documented in the chart as having been performed when, the prosecution alleged, it had not been delivered. The contrast between what the chart said was done and what the clinical and investigative evidence indicated was actually done formed the backbone of the abuse and neglect charges and the falsifying records charges alike. In the central case, the 74-year-old resident who died on October 29th, the medical evidence presented by prosecutors indicated that untreated wounds progressed to a severe infection that contributed to the resident's death. The chief medical examiner's office was involved in the case, and the forensic findings regarding the infection and its relationship to the alleged failure of wound care were part of the prosecutorial case. 4 individuals were charged with felony abuse and neglect of a vulnerable adult resulting in death. The 4 included a night nurse, a nurse manager, and the facility administrator. The broader charges filed across all defendants included 7 counts of felony abuse and neglect, 2 counts of misdemeanor abuse and neglect, 2 counts of obstruction of justice, and 27 counts of falsifying patient records. A judge presiding over an early hearing in the case described the central allegations as, in their words, gut-wrenching. As the prosecution evolved, some charges were continued to later court dates, one falsifying records count was dismissed, and prosecutors indicated that additional serious charges related to additional alleged victims were anticipated. All of these matters remain allegations subject to the legal presumption of innocence, and the prosecution was ongoing and developing as of the records reviewed for this documentary. In response to the investigation, the Virginia Department of Health barred the facility from accepting any new residents while the investigation proceeded. The statewide policy response was significant. Virginia Attorney General Jason Miyares announced the establishment of the first Elder Abuse Investigation Center in Central Virginia on June 17, 2024, at the Shady Grove WMCA in Henrico County. The center joined a regional coalition, including Richmond, Colonial Heights, Chesterfield, Henrico, Hopewell, Hanover, Powhatan, and Goochland counties, creating a coordinated investigative infrastructure for elder abuse cases. The Attorney General stated publicly that Virginia had experienced a sharp increase in reported elder abuse cases in the preceding years. The phrase that emerged from this case in nursing and healthcare policy discussions is simple and precise. Documentation is care. A false chart entry is not a clerical error or an administrative shortcut. It is a substitute for care, a record that says care happened so that no one looks for the care that did not. In the Colonial Heights case, the text messages said what the charts did not, that the patients who could not talk were the ones who did not get their medication. The messages were the record that told the truth the charts had concealed. Case 9. Tahia Sherwood. An 82-year-old woman noticed her wedding rings were gone, then her diamond bracelet, then her Rolex watch. The items had been kept in her bedroom. The only people with regular access to that bedroom were the in-home nurses hired to care for her. This is the Sherwood file. Ann Kellum was 82 years old and lived in Virginia Beach. She had mobility limitations that required her to rely on in-home nursing care for her daily needs. In-home nursing care is a common arrangement for elderly individuals with medical conditions that limit their independence but do not require full-time institutional care. The model depends entirely on trust. A caregiver enters the patient's home, often their private bedroom, and provides intimate personal care without any institutional oversight present. There is no charge nurse on the floor. There is no second staff member in the room. There is no surveillance system in the bedroom of a private residence. In April of 2024, Ann Kellum discovered that several items of personal property were missing from her bedroom. The missing items included a ring holder containing her wedding rings, a diamond bracelet, and a Rolex watch. The combined reported value of the missing property was more than $24,000. Because the items were kept in her bedroom, a private space accessible during her care, suspicion focused on individuals who had legitimate access to that room. The Virginia Beach Police Department opened an investigation. In theft cases, investigators frequently turn to the secondary market where stolen property is converted to cash. Pawn shops are a central element of that market. In Virginia and across the country, pawn shops are required to record the identity of individuals who sell or pledge items, along with a description of the items and the date of the transaction. Those records are often transmitted to or made available to local law enforcement as part of routine regulatory reporting. This creates a documented trail from the stolen item to the person who brought it in. In this investigation, that trail worked. Virginia Beach police traced the missing rings and the diamond bracelet to a pawn shop, identified the individual who had sold them, and made an arrest. Ann Kellum later described the arrest in her account of events, saying that officers positioned a law enforcement vehicle to prevent the nurse from leaving as they arrived at the home. The Rolex watch had not been recovered at the time of the most recent reporting reviewed for this documentary. The individual identified as the suspect and arrested in connection with the investigation was Tahia Sherwood, one of the nurses who had been providing in-home care to Kellum. Sherwood was charged with 4 counts of obtaining property by false pretense and 1 count of grand larceny. These charges are allegations. Sherwood is presumed innocent unless and until proven guilty in a court of law. A preliminary hearing was scheduled following the arrest, and the available reporting reviewed for this documentary does not reflect a final disposition of the charges. The evidentiary core of this case was the property trail, the items themselves, the pawn records, and the demonstrated access that in-home caregivers had to the patient's private bedroom. No laboratory analysis was required. No surveillance footage was necessary. The records that pawn shops are legally required to maintain under Virginia law documented the transaction that connected the missing property to the suspect. The case raises questions that extend beyond the individual facts. The in-home care setting creates a category of patient vulnerability that institutional settings, for all their documented failures, at least partially address through their physical infrastructure. Charge nurses, medication dispensing records, shift overlap, and in the wake of cases like the Strotman NICU investigation, surveillance systems. The private home has none of these. The caregiver enters alone. The patient receives care that no one else observes. The patient's belongings are present in the same space. Virginia, like most states, requires background screening of in-home care workers before placement. Agencies bear responsibility for the conduct of workers they place, and the matter of what liability exists when a placed worker commits a crime against a patient is an active area of civil litigation and regulatory policy. The Sherwood case added to the factual record that regulators, lawmakers, and agencies use when evaluating whether current screening and oversight standards are adequate for the home care setting. What was taken from Ann Kellum was not only jewelry. A wedding ring is not a piece of property in the ordinary sense. It is a personal document of a relationship, irreplaceable in its meaning regardless of its appraised value. The criminal law can recover the assessed value through restitution. The pawn record can trace the bracelet and the rings. It cannot trace what they meant. Case 10. Vicki Lynn Dowdy. Nearly 2,000 hours of home health care, billed and paid for by Virginia Medicaid. The patients were entitled to receive that care. The evidence established they did not. This is the Dowdy file. Vicki Lynn Dowdy was 55 years old and lived in Roanoke, Virginia, in the western part of the state. She worked as a home health attendant, a person hired to provide personal care and health-related assistance to individuals in their own homes who cannot manage those tasks independently. She was contracted to provide services to Medicaid recipients, which means her compensation came from the Virginia Medicaid program, a joint federal and state health insurance program that covers certain low-income individuals and individuals with disabilities. Her assigned caseload included 2 specific individuals. Court records identify them only as Individual 1 and Individual 2. These were not patients in a hospital. They were people living in the community, in their own homes or residential settings, who had been determined by the Medicaid program to require personal care and respite services, assistance with daily living activities such as bathing, dressing, meal preparation, and personal hygiene that they could not provide for themselves. In the consumer-directed home care model, which Virginia uses for certain Medicaid personal care services, the attendant's service hours are documented through a self-reporting system. The attendant submits timesheets recording the hours worked and the services provided. Those timesheets generate Medicaid claims. Medicaid pays based on what the timesheet documents. The only contemporaneous verification that care actually occurred is the timesheet itself, and the only person completing the timesheet is the person who is supposed to have provided the care. According to court documents, from January 16, 2021 through March 30, 2022, a period of approximately 14.5 months, Dowdy submitted fraudulent timesheets to the Virginia Medicaid program. She billed for 1,970.5 hours of personal home health care and respite services that she did not deliver to Individual 1 and Individual 2. As a result of those fraudulent billings, Medicaid issued payments totaling $24,760 for services that were never rendered. The case was investigated by the Virginia Attorney General's Medicaid Fraud Control Unit in conjunction with the United States Department of Health and Human Services Office of Inspector General. Medicaid fraud control units exist in every state, created and funded jointly by state and federal governments specifically to investigate and prosecute fraud in Medicaid-funded programs. The HHS Office of Inspector General is the federal oversight body responsible for protecting the integrity of Medicare, Medicaid, and other federally funded health programs. Fraud investigations in consumer-directed home care typically use a combination of billing data analysis, records review, and investigation of the attendant's actual whereabouts during claimed service hours. When an attendant bills for hours of care at a specific recipient's home, investigators can examine whether the attendant was documented elsewhere during those hours, through phone records, financial transactions, electronic location data, or other records that establish presence or absence. The contrast between a claimed service hour and evidence of absence during that hour is the documentary foundation of the fraud finding. Dowdy pleaded guilty to federal healthcare fraud. The prosecution was announced jointly by the acting United States Attorney for the Western District of Virginia and the Virginia Attorney General's Office, and was handled by an Assistant United States Attorney working alongside a Senior Special Assistant United States Attorney from the Attorney General's Medicaid Fraud Control Unit. The cooperative prosecution model, federal and state working together on a single case, reflects the structure of the consumer-directed care fraud enforcement framework. Upon her guilty plea, Dowdy faced a maximum sentence of up to 10 years in federal prison. She was ordered to pay $24,760 in restitution to the Virginia Medicaid program, the full amount of the fraudulent claims paid out. In addition to the criminal penalty, federal regulations provide for mandatory exclusion from participation in all federally funded healthcare programs for a minimum of 5 years following a conviction for a program-related offense. That exclusion effectively ends a caregiving career, because any employment providing care to Medicaid or Medicare recipients would be a federal violation. We are presenting the sentencing exposure and the restitution order as documented. The final sentencing disposition, whether a judge imposed an active prison term and for how long, is not confirmed in the records reviewed for this documentary at the time of preparation. This case, at its surface level, is a financial fraud case. Falsified timesheets, unauthorized payments, restitution owed to a state program. But the legal framing should not obscure the human reality of what the fraud represented. Individual 1 and Individual 2 were people who had been assessed by the Medicaid program as needing personal care they could not provide themselves. They were approved for that care. They were assigned a caregiver. They were entitled to receive assistance with the daily tasks that their own condition prevented them from managing. The timesheets said they received it. The evidence established they did not. The consumer-directed home care model is designed to support people in living in their communities, rather than in institutions, a goal with enormous value for quality of life and with significant cost benefits for the healthcare system. It depends on honest timekeeping. It depends on caregivers who show up and do the work and report only the hours they actually provide. When that system is defrauded, the person harmed is not primarily a government program. The person harmed is the individual who was left unserved during the hours the timesheet said help arrived. The Dowdy case is the quietest crime in this documentary. There is no clinical setting, no medication, no medical record, no laboratory test. There is a ledger and the empty hours where care was supposed to go. For a vulnerable adult in Roanoke, Virginia, dependent on a home attendant to get through the day, an hour billed and not worked is not an accounting discrepancy. It is an hour alone.